Let's look at Chapter 5, Customer Accounts. We do understand that customer accounts is covered heavily in detail on the SIE exam. So during our conversation for the Series 6 top-off exam, we're going to focus in on the most heavily tested customer account topics that you will see pop up on your Series 6 exam. So what do we request from a client? Their telephone number, occupation and employer, the annual income, their net worth, their investment objectives, and citizenship. Citizenship status. These items are requested. That means that the investor is not required to give us these details. So what happens if a client does not provide the registered representative with all of the requested information? The registered rep can still open the account, although the registered representative cannot make suggestions for investment vehicles for that client. All the trades in that account would need to be unsolicited, or the customer's idea. So we can open up an account without the requested information, but as a registered rep, I cannot sit there and make any recommendations. The customer would have to make sure that all of their trade requests are unsolicited or the client's idea. There are also things that must be required to get before we can open an account. Regulation SP, this is the regulation that talks about the firm's privacy notice, who they can share information with and when. So the statement of privacy must provide retail customers with the firm's privacy notice, and they must also have acceptable forms for the customer to opt out of S&P. So if we have a customer who uses our broker-dealer and they decide to finally sign the opt-out notice, we can't share any of their information with other firms. We still, though, can send their information internally. So with the opt-out notice, what are some acceptable ways that we can actually get customers to opt out? First, a reply form together with the opt-out notice. Second, providing an electronic means to opt out. Third, a toll-free number that customers may call. And finally, a checkoff box list that they can use to opt out. So who signs the new account form? It's the principal and the registered representative. Customers do not sign the new account form. This allows firms to open the account online or over the telephone. Now, a lot of you may have looked at the account form at your firm, and there's a place for the customer's signature. We have to assume that the test is focusing on the FINRA regulation, not what our firms may or may not do. We have to look at the fact that customers are not required to sign the new account form. Sometimes students ask, why is this? And the reason why customers don't have to sign it is because a client has signed a pre-dispute arbitration agreement, which means they have already agreed initially by signing the arbitration agreement that says they cannot sue the registered representative or the firm for any monetary losses or issues. Now let's take a look at a discretionary account. So a discretionary account, by definition, is one where a customer gives the trading authority of their account over to a third party or a first party, and that requires a signed POA or power of attorney, and that signature must be guaranteed before the registered rep can use it in the industry. There are three different types of discretion. We have a first party discretion, which is what we always assume, and that's the broker-dealer who has the ability to go and do trades on behalf of the customer. Second-party trading authorization gives the customer themselves, and third-party authorization is anyone else besides the broker-dealer and the customer who has trading authorization over a customer's account. So when we're looking at getting discretionary authority over a client's account, the client fills in or they fill out a power of attorney. The power of attorney can either be limited or full, and just so you know, we never really want a full power of attorney of registered reps. We want limited, and limited is usually what we deal with. With limited power of attorney, it just gives the registered rep the ability to trade on behalf of the client. They can't take anything out of the account making withdrawals. With full power of attorney, you're giving another party the ability to work as you as the customer in any financial transaction within the account. So with full power of attorney, the power of attorney can sell your car, sell your house, do your stock trades, take money out of your brokerage account, and so on and so forth. So I hope you can see why it's very few and far between that we see full power of attorney on a customer account. 99% of the time, power of attorney is always limited. All power of attorney ends during death. There is durable power of attorney, which goes past incompetation, but all power of attorney ends on death. So a durable power of attorney continues past incompetation, whereas a limited power, undurable power of attorney ends during incompetation. No power of attorney goes past death. Remember, it's rare to see full power of attorney on an account 99% of the time. Power of attorney is always limited. Almost always. So now it comes to the 3A order. This is not discretionary authority. They actually call this a market not held order on the floor of any exchange. So with a 3A order, the A stands for the action, which is buy or sell, the amount, which is the number of shares in the dollar amount, and then finally the asset or the security. If the investor provides their registered representative with these three A's verbally, the trade is good that day. So this is the only time we can accept verbal power of attorney to do a trade for a client. So buy 100 shares of ABC stock. The trade is good that day. So that is the only time we can accept verbal authority to do a trade for a client. So if we can't do that trade today, and let's say that the customer still wants to do it, they'd have to call the next day in order to put in another 3A order. So it's only good for one day, that day. So another thing that I thought we would do is run through some of the different type of accounts for our clients. Let's start by taking a look at accounts for retail customers. An individual account is an account with one owner, and when they pass away, that goes through the investor's probate, through their final will and testament. On a transfer on death account, there is one owner on the account, but now there are beneficiaries assigned by the owner. So they can appoint people to get that remaining money in their account, which they can let continue to grow. They can withdraw it. They can do whatever they want. The nice thing about these transfer on death accounts is that they avoid probate. Transfer on death is usually abbreviated TOD accounts. Next is a joint account. We have two different joint account types, rights with survivorship and tenants in common. The joint account with rights of survivorship, or JTWROS accounts, this is the most common style of joint account that we see. Both owners share in the proportionate ownership of the securities held within the joint account, and if one owner dies, then the remaining owner or owners retain the rest of the account. With a tenant in common account, each owner owns a certain percentage of the account based upon their investment. So if I had a joint account with someone else and I put in 30%, and let's say John Doe put in 70%, my beneficiaries get my 30% of the account from my portion. John Doe will retain their portion. So what about senior citizens? They would require, FINRA requires firms to have firm policy procedure regarding documentation for suspicious activities and how we escalate it to protect the investor. So once a firm has identified a problem, we need to reach out to that person's designated contact person. So we have to get a hold of our client, our senior citizen client's contact person, in order to verify the trades that we're about to do is the customer's true authentic request and they are not pressured by anyone else to perform these trades. So we have to communicate with that designated contact person. We also need to maintain frequent contact with the customer and consult appropriate state records in order to ensure we continue to protect the customer. So we need to prevent exploitation for investors that are 65 years of age or older, and for investors that are 18 and older with serious mental or physical impairments. Now, in order to prevent exploitation, if we've identified a problem, we can put the account on a 15-day hold, making it so that nobody can take money out of the account while we research, and that is when we know to contact our trusted contact person. I want to remind you that the trusted contact person doesn't have to be a family member. They can be an attorney, a friend, your next door neighbor, whoever you feel comfortable with having as your trusted contact person at the broker-dealer. But usually it is somebody who is relatively familiar with the person and deals with them on a day-to-day basis. If we want to open an account at another broker-dealer As an employee of a member firm, we have to get written notice to our executing member. So we have to tell our broker-dealer that we are opening an account at another firm, and they have to give written permission in order to do so. So our employer have to give written consent for the account to be opened at another firm. When we open an account at the new broker-dealer, our firm can request duplicate confirmations and statements be sent to them, and that is upon request. If you are solely an employee of a FINRA member firm and you're only investing in mutual funds or closed-end funds or unit investment trusts or even 529 plans, you do not have to worry about this process. This process is for all other securities minus investment company products and 529 plans. So what about our different business entities? We have corporations, partnerships, and then there's this thing called a prime brokerage account. So when we open up an account for a corporation, we are required to get the corporate resolution and the corporate charter. So what is the minor difference between these two documents? The corporate resolution is the document that will be updated on a frequent basis because that is the document that tells everyone who, as an officer at the corporation, has the ability to direct trades on the behalf of the corporation. So that is the reason why we need the corporate resolution. The corporate charter, or it could be articles of incorporation depending on how we're set up and what state we're setting up in. With the corporate charter, it's the document that established the corporation and talks about how the corporation and its business is going to run. So we definitely need a corporate charter because we want to make sure that this corporation has the ability to invest in the securities that they want to invest in. We really need to make sure that we check the corporate charter, especially when a corporation wants to do an option account or a margin account. That has to be specifically designated in the corporate charter to use those account types. Otherwise, we can't do that for the investor. So within a partnership, we either have a general or a limited partnership. So in a general partnership, all of the owners are general partners and can help manage the business. With a limited partnership, we have some of those general managers, but then you have the investors, the money people, the limited partners. I always think of limited partners like silent partners, like show me the money, now go away, right? So if you're in a partnership, whether it's a general or a limited partnership, the beautiful thing about a partnership is that the partnership itself is not taxed, right? And so all of the earnings and all of the tax and liability flows over, passes through to the partners. And so you might have a tax liability as a limited or general partner. A prime brokerage account, this designates a single broker-dealer as a primary firm. So we understand that when a broker-dealer might be an amazing trader for debt securities, another broker-dealer might be really good at trading aggressive equity securities. So by opening up a prime brokerage account, it designates that single broker-dealer as a primary firm, and then they can direct trades to other firms as needed for the client's behalf. And so these are traditionally used by institutions that want to use different broker-dealer firms for executions on different types of trades. So they can do that, but under the umbrella of one like parent broker-dealer or one prime brokerage account. One of the things that we also need to take a look at are the accounts for fiduciaries. So the first type of account is a trust account. With a trust account, we have a trustee, and then we have beneficiaries for the trust. A copy of the trust agreement is needed, and we must keep it on file. When it comes to a trust account, the trustee must make all investment decisions based on the investment criteria for those beneficiaries. It's in their best interest, not the trustees. With a guardian account, this is usually when parents have passed away and there's nobody that has the ability to take care of this individual. So with a guardian account, a court will come in and appoint a legal guardian, and that is when we establish a guardian account. Where you might see some extra questions would be on custodial accounts. Think of UTMA and UGMA, the Uniform Gift to Minors Act and the Uniform Transfer to Minors Act. So with an UGMA or UTMA account, there is always one custodian and one minor. The custodian has to be an individual. It does not have to be the child's parents. So with an UGMA or UTMA account, the money that is put in there is the child's money. It is an irrevocable gift to the minor. We cannot take it back. Therefore, the tax liability is up to the child. They are assumed a kiddie tax law and subject to kiddie tax laws. We don't have to know the subjects of kiddie tax laws on securities tests. That's something we'd have questions for on a CPA or more of a certified public accountant question. We'd give that to the tax advisor. What we want to remember about these custodial accounts is that the child is always the owner of the money, but the child cannot take the money out on his or her own until they have reached the age of majority for their state. Some states' age of majority is 21, while other states have an age of majority at 18. So let's take a look at our anti-money laundering rules. In 2001, the Patriot Act was passed. The Patriot Act of 2001, and one of the things about the Patriot Act and the reason why it was designed was to prevent the funding of terrorist activities through U.S. broker-dealers. So part of the Patriot Act leans into the Bank Secrecy Act that banks have used for years regarding how do we report large cash transactions. And under the Patriot Act of 2001, a currency transaction report, or CTR, we call it affectionately a CTR, currency transaction report, has to be sent in to FinCEN, the Financial Crimes Enforcement Network, if the investor has more than $10,000 that they are investing in cash or a cash equivalent. So cash would be money, right? Cash equivalents for securities would be like an old bearer bond that has no ownership recorded, cashier's check, a money order, a wire, even a cash bank deposits. Those are all cash equivalents. If you have an investor that's writing a check off of their bank account, then that's not a problem. We can trace that money back to their bank account. But it's all the other things that we really get concerned with. The other thing that could trigger a CTR would be structuring. So making up of small deposits. And people know that we have this regulation, right? So what they try and do is break up. In the morning, they'll deposit $3,000. In the afternoon, another $7,000. And then another $5,000 later on that day. We'll take all of that and say, hey, look, investor, the combined total is greater than $10,000. So we still have to file a CTR. So people try to do this all the time, but it doesn't work. It's not something that they get away with if they're using this money for illegal funds, right? If it's not clean money. A suspicious activity report, usually it's a cash or cash equivalent transaction that's $5,000 or more within 30 days. We have to file this. So what are some red flags? When would we file suspicious activity reports? We're going to do our due diligence as registered reps on customers, right? So you have to ask your investor, hey, what is your business? How are you earning your money? What do you sell? What do you make? And if they're reluctant to reveal this information about their business activities, assume that's a huge red flag. Because I have never met a business owner in my life that has a business. Every business owner gets excited and amped up about what their business does. They want to share it with you. So if they're not excited, you probably want to question it. So furnishing suspicious or unusual identification, you typically, you might go to a training about looking at IDs to make sure that they're matching up to the state-specific requirement and they aren't fake. So they have to make sure that we're doing that due diligence to make sure they are who they say they are. If someone gave me a fake ID and I was able to find it, that definitely is a red flag. The other thing is engaging in sudden and unexplained expensive wire activities, especially if they are wires coming in or out of the United States from another country. Another piece of miscellaneous information on customer accounts surrounds client account statements. So we have active accounts and we have inactive accounts. And active just means that they're doing regular trades. The earnings are reinvested. Active accounts will get a statement monthly. So an inactive account, though, we're not doing any more investing, we're not earning a whole lot, those statements will come out quarterly. So if there's trading in the account statement must be sent monthly. If a question says at a minimum, when must an account statement be sent to a customer? Well, the minimum is quarterly. But if it's active trading, that's for an inactive account would be quarterly. But if it's active trading, we consider an active account if the question says for an active account, then the statement would be said monthly. What happens if an investor passes away? So during the death of a customer, for all individually owned accounts except for joints with rights or survivorship, we'll cancel all open orders, freeze the account from removal of assets, note the customer is deceased on the paperwork, and then await further instructions from the executor of the customer's estate. If it's a joint with rights or survivorship account, if one owner dies, the account automatically transfers over to the surviving owner. So we have a different stipulation that we use there. It would just be sending in instructions along with the set and copy of the death certificates in order to transfer that account to the survivor. So with a joint tenants with rights of survivorship, it's a little bit easier than other individually owned retirement accounts. Record retention, according to FINRA, records of 3 years, customer communications, order tickets, and confirmations must be sent to customers. All customer complaints must be kept for 4 years, and just as an FYI, these are the original complaints. So if the customer wants to have their letter back, we can't send it to them. We can send them a photocopy, and then documents that have to be retained for 6 years are your customer account statements. FINRA set forth their own suitability measures. So FINRA has 3 different bases for making a suitable recommendation to clients. The first one is reasonable basis, which reasonable basis, suitability, we make sure that this product or this fund is a reasonable investment choice for this type of investor. And we have customers that really utilize this on a regular basis. So for example, all growth investors, I like looking at the A, B, C in the XYZ growth fund. That's reasonable basis. But now when I look at my specific and customer suitability, I sit there and go, okay, John Doe is 25. He said he wants to invest in growth. Now I'm kind of looked at the two. The ABC growth fund is specifically for him the best choice, not the XYZ based on his own circumstances. That is customer specific suitability, finding that rare gem in that portfolio that's just right for that investor. Maybe they want to avoid front-end tax and they want a Class B fund. Quantitative suitability means, is the investor going to be okay with the amount of money they're going to invest? Sometimes the investor invests every single month, so we don't want to overextend them. Quantitative suitability is really important. We don't want them to invest more than what they can afford. So then we have regulations best interest, or Reg BI. This act requires broker-dealers and investment advisors put customer interests first. That means that broker-dealers are always going to be held to a suitability standard that we just took a look at, while investment advisors are held to a fiduciary standard, meaning they have a legal obligation to put customers' obligation first. And the last thing I want to mention is that a broker-dealer or a firm can be both a broker-dealer and an investment advisor at the same time. Also, under Reg BI, customers must receive Form CRS, Customer Relationship Summary. This document must be in plain English, meaning everyday language that's easy to understand as a customer. And the firm is the firm working as a broker-dealer or an investment advisor, or both, and the compensation, the suitability standards or fiduciary standards that we met, and the fees and costs also have to be disclosed. And finally, the firm or associated person had any reported disciplinary events. So Reg BI requires us to fill all that information out on Form CRS. You guys, this is all I wanted to review during customer accounts. Now you know what to do. Go jump into the millionairesintraining.com practice exams and do your practice questions and study those explanations. When you get done with the chapter, take quizzes, review your questions and explanations, and try and get better and better scores. Review more of the videos if you need to lay more foundational knowledge. I look forward to seeing you back on Chapter 6 for Securities Regulations. I know we're all very, very excited already, right? So we're moving forward with our Series 6 top-off exam. Great luck on this chapter. I'm Colin Kleck, and I'll see you in the next video.